I'm going to call this meeting to order. If everyone will stand for the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Reading and approval of the minutes for the hearing or the Board of Commissioners meeting that was held on December 15th, 2021. Do I have a motion to approve?
Motion. Second.
On the question, all in favor?
Aye.
Aye. Opportunity for the public to address the board on agenda items only. There's no one here. Okay. Ordinance 21-0314, ordinance number 276, second reading. Brian.
Thank you, Madam Commissioner. Whereas Lackawanna County, duly organized and subsisting as a political subdivision of the Commonwealth of Pennsylvania, anticipates the receipt of both current taxes and current revenues during the fiscal year ending December 31st, 2022. And whereas the county desires to borrow for the purpose of meeting current expenses by issuing a tax and revenue anticipation note to be repaid from inter alia, those taxes and revenues all in accordance with local government unit debt Act as codified by the Act of December 19th, 1996, PL 1158, number 177, as amended. And whereas required by Section 8126 of the Debt Act, the chairwoman of the Board of Commissioners of the county, the chief of staff, and the county solicitor have not more than 30 days before the date on which this ordinance is being adopted, and furthermore hereby confirm on this date made an estimate from taxes now levied and assessed and from other budgeted revenues of the taxes and revenues to be received and the expenditures to be made during the period when the note will be outstanding, and have certified that estimate by a duly executed document. Whereas PNC Bank National Association has submitted an accepted proposal for the purchase of the note. Now therefore be it resolved by the Board of Commissioners of the county as follows. Section 1, authorization. The county hereby authorizes the issuance of the note in the principal amount with a specific term stated in the proposal and attached certificate and transmittal to the Department of Community and Economic Development. Section 2, the form. The note shall be designated Tax and Revenue Anticipation Note Series 2022 and shall be in the form of a single instrument in the principal amount of $10 million. The note shall bear interest at a tax-free rate of 0.60% per annum. The note may be subject to redemption prior to maturity in accordance with the proposed register form without coupons will be negotiated and dated the date of delivery and will be payable as to the principal interest on December 30th, 2022 upon presentation by the purchaser to the county in the coin or currency of the United States of America that is legal tender for the payment of public and private debts at the time and place of the payment. The exact form of the note will contain an unconditional promise to pay the principal of and interest on the note to the purchaser when due, will pledge and grant a security interest in the collateral identified in Section 5 of this ordinance, will recite the valid issuance of the note under the Debt Act pursuant to proper corporate authority, will prohibit personal recourse against officials of the county, will certify proper achievement of all conditions precedent to the issuance of the note, and will designate the note as a qualified tax exempt obligation under Section 265B3 of the Internal Revenue Code of 1986 as amended. Section 3, execution and delivery. The note will be executed by the chairwoman of the governing body and will have the corporate seal of the county affixed thereto or printed thereon, duly attested by the chief of staff. To the extent that any one signature on the note is manual, the other signatures may be facsimile. The designated officers are further authorized and directed to deliver the note to the purchaser upon the terms and conditions hereinafter and in the proposal provided. Receive the proceeds therefore, execute and deliver such certificates and other closing documents, and take each other action as may be necessary or appropriate in the order to effectuate the proper issuance, sale, and delivery of the note. Section 4, filing. The designated officers are hereby authorized and directed to certify and transmit copies of this ordinance, the proposal, and the certificate as to collections and expenditures, which includes a calculation of the cumulative cash flow deficit calculated in accordance with the provisions of the Internal Revenue Code of 1986 as amended, and the United States Treasury Department Regulation 1-148-6D3, the contents of which are hereby approved to the department of Community Economic Development of the Commonwealth of Pennsylvania or to the purchaser for such filing. Section 5, security. As security for the payment of the note, the county pledges and grants for all the benefit of the owners from time to time of the note a first lien and charge on and security interest in all of the taxes, accounts, and general intangibles, including total revenues of the county to be received during the period that the note will be outstanding, together with such amounts to be received during fiscal years subsequent to the year during which the note is issued in the event that the county defaults on the payment of the principal or the interest on the note. The county hereby authorizes and directs the purchaser to file a financing statement pursuant to the Uniform Commercial Code to perfect the security interest hereby created. All expenses of such filing shall be borne by the county. In the event of any default on the note or hereunder, the county agrees to pay the reasonable expenses of the purchaser, including the court costs and attorney fees incurred in collecting the amounts due. Section 6, the general obligation. The note issued pursuant to this ordinance shall be a general obligation of the county. The county hereby covenants with the purchaser that if funds are not available for the full payment of the note within the fiscal year in which it was issued, then the county will either, one, include the amounts necessary to pay the note in its budget for the next fiscal year pursuant to Section 8125 of the Debt Act to the extent then permitted by applicable law. Number two, fund such amounts within the next fiscal year in accordance with Sections 8129 and 8130 of the Debt Act. Or number three, provide for payment of the note by any combination of one and two. In all events, upon notice to and with the consent and agreement of the purchaser, and provided furthermore that in such an event of a default, if the county shall have executed and delivered certain credit, collateral, and/or security applications or agreements pursuant to Section 10 hereof, the general obligation pledge of the payment made by this Section 6 shall include and encompass all amounts in addition to the stated principal and interest due in respect of the note by the terms of such credit agreements and shall conform to the manner and procedures for payment, if any, set forth therein, or provided at the direction of the purchaser, either as owner or subrogee of the note. Section 7, tax covenants. Subsection A, the county hereby covenants with the owners from time to time of the note that it will make no use of the proceeds of the note, which if such use had been reasonably expected on the date of the issuance of the note, would have caused the note to be an arbitrage bond within the meaning of Section 148 of the code and the regulations thereunder, and that it will comply with the requirements of the code and regulations throughout the term of the note. Subsection B, if the principal amount of the note plus the principal amount of all other tax exempt obligations issued and to be issued by the county or by a subordinate governmental unit within its jurisdiction during the calendar year in which the note is to be issued exceeds $5 million, and if the gross proceeds of the note are invested at a yield greater than the yield on the note and are not expended or deemed to have been expended pursuant to in Section 148F4B3 of the code within 6 months from the date of issuance, the county covenants that it will rebate the U.S. Treasury within 60 days after the maturity date of the note. That amount of investment income on the note proceeds which exceeds the amount which would have been earned had the note proceeds been invested at a yield equal to the yield on the note. Subsection C. The county hereby designates the note as a qualified tax exempt obligation pursuant to Section 265B3 of the code and represents and covenants that the total amount of its obligations so designated and to be designated during the calendar year of 2022 does not and will not exceed $10 million. Section 8, award. The note is hereby awarded and sold at private sale by negotiation to the purchaser at par in accordance with the proposal and its terms as set forth in the foregoing and attached certificate and transmittal, which, as presented at this meeting, is hereby accepted and directed to be executed by the designated officer. Section 9, costs. Unless otherwise agreed with the purchaser, all notice, filing, and legal fees properly incurred in connection with the issuance of the note will be paid by the county. The designated officers are hereby authorized and directed to pay all such reasonable expenses at the time of the settlement on the note. Section 10, letters of credit and guarantee of payment and subrogation. The county acknowledges the right of the purchaser to negotiate some or all of the note to subsequent third-party owners from time to time and at any time during the term of the note. Moreover, the county recognizes that the purchaser may choose in its absolute discretion and at its own cost to provide letters of credit, put agreements, collateral amounts, and such other and similar guarantees of payment by the purchaser to the third-party owner as may be necessary to facilitate the negotiation of the note to the subsequent owners. In consideration of the beneficial interest rate afforded the county by the increased and facilitated marketability of the note, and in such event, the county agrees and the designated officers are hereby directed to execute and deliver any and all credit, collateral, and security applications and agreements as may be necessary to, in the reasonable discretion of the purchaser and according to its standard business practices to provide further assurance to the purchaser of its rights, either as an owner or subrogee under the guarantee arrangement to receive payment in the full of the principal of and interest on the note when due. In the event any payment or of principal or interest or both is made to any of the owner of any note by a draw on the letter of credit issued by or other guarantee of payment made by the purchaser, such payment will not extinguish the obligations of the county under such note. The purchaser shall become the owner and subrogee of the note with full rights to enforce payment of the amounts due in respect of the same. Section 11, ordinance contract. This ordinance is a contract with the purchaser and any other subsequent owners from time to time of the note. Section 12, inconsistent actions. All prior ordinances or parts thereof inconsistent herewith are hereby repealed. Madam Commissioner, that concludes the second reading of the ordinance. You may now call for a vote.
Do I have a motion to approve 21-0314, which is ordinance number 276?
Motion. Second.
On the question. All in favor?
Aye.
Aye. Resolutions 21-0315, approving a local economic revitalization tax assistance addendum for Glenmar Senior Living.
Whereas the General Assembly of the Commonwealth of Pennsylvania passed Act 76 of 1977 and subsequently amended such legislation on July 13, 1988, known as the Local Economic Revitalization Tax Assistance Act, LRTA, authorizing local taxing authorities to grant a tax exemption for certain improvements constructed on defined deteriorated properties. And whereas pursuant to the LRTA statute, the Riverside School District adopted resolution number 34 on August 11, 2014, that granted Hemingway Development Limited Partnership a tax exemption for certain improvements to be constructed on the real estate owned by Hemingway Development Limited Partnership as set forth in the attached resolution. And whereas pursuant to the LRTA statute, the Borough of Moosic adopted resolution number 8 on August 12, 2014, that granted Hemingway Development Limited Partnership a tax exemption for certain improvements to be constructed on the real estate owned by Hemingway Development Limited Partnership as set forth in the attached resolution. And whereas Hemingway Development Limited Partnership sold a portion of the land to Glenmar Senior Living LLC by deed dated October 19, 2017, Lot 1B, PIN number 18601-010-016, a copy of which is attached hereto and made part hereof as Exhibit Deed. And whereas Glenmar Senior Living LLC has developed a personal care facility on the real estate described in the deed dated October 19, 2017, Lot 1B, PIN number 18601-010-01601 revised, a copy of which is attached hereto and made part hereof as Exhibit Deed. And whereas Glenmar Senior Living LLC has requested the Riverside School District to extend the provisions of resolution number 34 of August 2014, dated August 11th, 2014, and whereas the amended resolution addendum number 1, dated September 14th, 2020, and that all other items and conditions of resolution number 34 of August 2014, dated August 11th, 2014, which shall remain unchanged and in full force and effect to exempt Glenmar Senior Living LLC from the payment of the improvement portion of the Riverside School District real estate tax for the tax year 2020 and to 2021. And whereas Glenmar Senior Living LLC has requested the Moosic Borough extend the provisions of resolution number 8 of August 2014, dated August 12th, 2014, and whereas amended And whereas by amended resolution addendum number 1 dated October 13th, 2020, and that all other items and conditions of resolution number 8 of August 2014 dated August 12, 2014, which shall remain unchanged in full force and effect to exempt Glenmora Senior Living LLC from payment of the improvement portion of the Borough of Music's real estate tax for the tax year 2020 through 2021. And whereas Glenmora Senior Living LLC has requested the County of Lackawanna extend the provisions of the county resolution number 14-0161 of August 2014, dated August 27th, 2014, by amending resolution number 14-0161, and that all other items and conditions of resolution number 14-0161 of August 2014, dated August 27th, 2014, shall remain unchanged and in full force and in effect to exempt Glenmora Senior Living LLC from the payment of the improvement portion of the County of Lackawanna real estate tax for the tax year 2021. And whereas Glenmora Senior Living LLC, its successor, and assigns shall comply with the regulations for LERTA exemption, which are set forth on attached resolutions number 34 of August 2014, number 8 of August 2014, and number 14-0161 of August 2014, incorporated by reference, and now therefore based upon the representations made by Glenmora Senior Living, the County of Lackawanna hereby agrees to the following: to exempt Glenmora Senior Living LLC from payment of the improvement portion of the County of Lackawanna real estate tax for the year 2021, and upon the submission of the application for real estate tax exemption on certain improvements to the Riverside School District, the Borough of Music, and the County of Lackawanna, Glenmora Senior Living LLC shall be exempt from real estate property taxes otherwise payable to the County of Lackawanna as a result of an increase in the tax assessment for Glenmora Senior Living LLC, parcel PIN number 18601-010-01601, attributed to the cost improvements constructed thereon. Be it resolved that for a period of 10 years beginning January 1st of the year following the year in which the borough issues an occupancy permit for the improvements to the Glenmora Senior Living LLC, not reading the PIN again, shall be exempt from the real estate property taxes otherwise payable to the county as a result of an increase in the tax assessment for the Glenmora Senior Living LLC attributed to the cost improvements constructed thereon. Adopted at a regular meeting of the Board of Commissioners of Lackawanna County held on December 30th, 2021. Madam Commissioner, here to speak upon that.
Thank you, Chief Jeffers. As indicated, this is a LERTA application submitted by Glenmora Senior Living. This got a little convoluted along the way. The construction of the project was completed and they received their occupancy permit in October of 2019. Therefore, under the LERTA guidelines, the LERTA would typically take effect on January 1 of 2020. However, the contracting officer for Glenmora Senior Living or someone on their behalf did not file or timely file the LERTA application, which is to be filed at the time that you pull your building permits so that the assessment for the land can remain and the improvement set at zero. So they've made an application after they received their occupancy permit. As is typical, we asked the first two taxing bodies, the school district, Riverside, as well as the municipality, Music, to act upon their application, which they have. So they've approved it, and they've provided the LERTA retroactively to senior living back to 2020. In discussing the matter with Brenda and our team, I've advised that I don't think it's appropriate that we apply the LERTA retroactively to 2020, but that we can apply it commencing in 2021, because if we apply it retroactively, then we really undermine the integrity really and the reasoning behind when LERTA is to be filed, and we'd open, I believe, a Pandora's box for others that would come in after the fact. So therefore, we are granting it, or if the commissioners deem it appropriate to grant, you would be granting the LERTA commencing January 1st, 2021, so they get relief for this year because the taxes are not delinquent yet until the 31st. However, they are still going to be required to pay the county portion of their taxes for 2020. I've spoken with the principals regarding this matter. They understand that and the reasoning for the same. Thank you.
Okay, does anybody have any questions for Frank? Do I have a motion to approve resolution 21-0315?
Second.
On the question? All in favor?
Aye.
Opportunity for the public to address the board. No one's here. Commissioner, other business, Chris?
Happy New Year, everyone.
Happy New Year.
Jerry? Ditto. We'll take a motion for adjournment.
Motion.
On the question? All in favor?
Aye.
Aye. Thank you.
Thank you. Happy New Year, everyone.